Miss Westbank.
My lord, my ladies, I appear together with Mr. Pay for the Appellant, Magic Investments SA. My learned friends, Mr. Doherty and Mr. Tolson, appear for the Respondent, Mr. Broadbent. Before we begin, a small housekeeping matter. May I check that you have received my client's supplemental skeleton argument from the 14th of April? My lady nods.
Yes, I think we all have.
Thank you. Also, there's a letter from my learned friends instructing solicitors DWF, which was dated the 20th of September 2024. It was opposing the application for permission to appeal after the first hearing before Deputy ICC Judge. Did that also reach?
That reached me at the same time as the skeleton argument.
Yeah.
It all came in the one.
Yeah, it was together with the...
I'm afraid I don't think I do have that.
We will source another copy if
Yep.
we need it. I'm not sure I'm going to actually need to take you to it. And finally, there was some correspondence last night from my learned friends instructing solicitors DWF, where they asked to put a letter and an order before the court in relation to the disclosure review document. That reached you.
That did reach me. All of us.
I'm grateful.
Yeah.
I'm grateful. Thank you, my lord. As the court is aware, this appeal relates to the summary disposal of my client's Section 994 petition. The trial of the petition was due to take place on the 15th of May 2024, so almost exactly 2 years ago. It was supposed to be for 4 days plus 1 day of pre-reading. It was vacated on the 19th of April 2024 by the order of the then Deputy ICC Judge Agnello KC. I say then because the judge is now a full-time ICC judge, so I'll refer to her as the ICC judge rather than the deputy. The appellate judge, Mr. Justice Marcus Smith, refused the appeal for reasons contained in a judgment dated 25th of July 2025. And as the court is no doubt aware, my client pursues 2 grounds of appeal in relation to the decision of the appellate judge. The grounds of appeal are in the core bundle at tab 4 at page 63. This is a second appeal, of course, and we obtained permission to appeal from Lord Justice Miles in relation to grounds 1 and 2 on the 14th of November 2025. Ground 1 essentially challenges the appellate judge's conclusion that Magic had no real prospect of successfully establishing a trial of what he termed the pure dilution allegation. Ground 2 challenges the conclusion of the appellate judge that Magic had no real prospect of successfully establishing its case on the board seat allegation. We say that's really a short question of interpretation of the relevant documents. Grounds 3 and 4 were advanced in the alternative as being compelling reasons for permission to appeal. Essentially, they were addressing the manner in which the decision was reached. Ground 3 related to the omission to deal with Magic's case in relation to the pure dilution allegation in its full breadth in terms of the law that we cited. And ground 4 related to the judge's reasoning on the board seat allegation, where we relied upon factual matrix material which the judge didn't look at or refer to, and instead the judge, we say, relied upon points that weren't argued by either side. Those grounds 3 and 4 have fallen by the wayside. We only obtained permission for grounds 1 and 2. Lord Justice Miles took the view that grounds 3 and 4 didn't really add anything because we were going to have the argument on the substance. I just note that because, and it may just be an oversight, in the somewhat lengthy respondent's notice that's been filed by Mr. Broadbent, which is at tab 5 of the core bundle, if one goes to where the grounds are set out, which begins at page 75, you'll see in the 2 subheadings here that references are made to grounds 3 and grounds 4. Those are not live. Taking stock of where we are, as the court would have seen, in relation to the pure dilution allegation, this was dealt with by the appellate judge quite briefly, really in 2 paragraphs. The position we've now reached is that Mr. Broadbent accepts the appellate judge's reasons did not provide a sound basis for his decision. That's paragraph 31, skeleton argument of Mr. Broadbent. If you want the reference, it's core tab 2, page 38. However, Mr. Broadbent contends that the appellate judge was nonetheless right to reject the pure dilution allegation for different reasons. Necessarily, therefore, those are additional different reasons which are advanced by way of Mr. Broadbent's Respondent's notice. The consequence is that ground 1 is, or the pure dilution allegation in ground 1 is essentially conceded, and so far as we're having the argument, it's going to centre upon Mr. Broadbent's Respondent's notice. I propose, therefore, to deal first with the board seat allegation, ground 2. I'll then set out my store on the pure dilution allegation, but to a somewhat limited extent, because I'll have to hear what my learned friend says on his Respondent's notice points on the pure dilution allegation. The Respondent's notice also raises a suite of further grounds why it is said that the appeal should be refused. Those include the suggestion that the appellate judge should have concluded the relief sought against Mr. Broadbent was disproportionate and should be summarily dismissed on that basis. There's also possibly an attempt to place reliance upon an offer to purchase shares. I'll have to come back once I hear what my learned friend says about that. In terms of timing, I've been in touch with Mr. Doherty. I understand that we have a day and a half. I doubt the court wants us to take a day and a half if we can avoid it.
We'll be delighted if it takes less time than that.
We will. I will endeavour to tailor my submissions to try and achieve that so far as it's within my gift. I'll endeavour to complete my first round of submissions then, obviously during the course of this morning. I should just raise, there is a transcriber. Does the court have any objection to a 5-minute break at some point mid-morning?
It isn't the court's normal practice to do that here.
Yes.
I'm sorry if that causes trouble for transcribers, but I suspect they're used to it.
Yes. We will push on then. Now, I'll turn then straight to ground 2, the board seat allegation, which was described by the ICC judge at first instance as a short construction point. Can I very briefly introduce the chronology to put my client's case into context? And we can probably do this most easily by looking at the judgment of Mr. Justice Marcus Smith, which is in the core bundle, tab 10. May I just check, is the court working with physical bundles? Yes.
Certainly, as far as I'm concerned, I am.
Yes.
Yeah.
I shall continue to give tab.
Thank you.
The board seat allegation, and you would have seen paragraph 1. I'll be very brief on this. Mr. Broadbent and Mr. Dixon founded the Greater Good Fresh Brewing Company Limited company in April 2010. Paragraph 2, they advanced loans to the company, included a loan by Mr. Broadbent of about 1.25 million. There were other loans, but these are the relevant ones. Paragraph 4, my client, Magic, subscribed for 103 shares in the company in 2021. It paid just under £1 million for those shares. As the judge points out, it works out as an implied value of the company of around £45 million at that time. Now, prior to my client's investment, there were negotiations as to the basis of the investment. There was an initial subscription agreement dated the 24th of March 2021. That had errors in it. So there was a further subscription agreement 2 days later on the 26th of March 2021. It's materially the same terms, save that a different number of shares, the correct number of shares, I should say, was identified in the second version. The day before the second subscription agreement, the company issued a letter which addressed Magic's right to nominate a director to the board. And this letter was dated the 25th of March 2021. There is evidence about this in its origination, and I'll take you to it, but in short, Magic's case was that it communicated to the company that it required a seat on the board because of relevant foreign exchange controls under South African regulations, I put it that way, which put restrictions on the outflow of money. And that, we say, is part of the relevant factual matrix which the court omitted to consider. Now, the investment proceeded, shares were allotted, and Mr. Chris Mayer, I think he was the former head of Investec Bank, was put forward as a director. There is or was an issue as to whether or not he was formally appointed. That's not germane to the issues before the court today. The point is that Mr. Mayer communicated in July 2021 that he didn't want to be in office. I think he'd been offered a role elsewhere. And so he either never took office or he resigned. The issue that arose was whether Magic was entitled to have someone else on the board. I just want to briefly show you Mr. Broadbent's defence on this. It's in the core bundle, tab 24. If I could ask you to turn to page 235, paragraph 13. You'll see Mr. Broadbent refers to the letter, and he says it recorded, amongst other things, about the issue of the shares, and then 13.2, Magic will thereafter be entitled to nominate someone to the board. The agreement set out in the nomination letter as to Magic's right to nominate someone to the board is referred to below as the nomination agreement. He says the letter accurately recorded the position as at its date, and then says, on its true construction, and conferred upon Magic only a right to propose a director for consideration and approval by the company, whether by the board of the company or by members of the company, and not a right to insist upon the appointment of any person whatsoever to sit on the board of the company. Just note, it's accepted that it's a contractual agreement. It's an agreement and it has to be construed. The question, the issue is as to the nature of the right. You'll see further at paragraph 21, at page 239, 5 lines up from the bottom of paragraph 21, it was said, in the premises, the right of Magic under the nomination agreement to nominate someone to the board of the company was fulfilled. This is a reflection of the argument of Mr. Broadbent that it was a one-off right that could only be exercised once, one shot. The ICC judge didn't accept that it was a one-off right. Strictly speaking, there was no respondent's notice raised in relation to that, but the appellate judge concluded that it was a one-off right. Paragraph 24, over the page. Sentence about midway through that says, in any event, and without prejudice to the fact that the nomination agreement was fulfilled by the appointment of Mr. Mayer, that's the one-off right, any right of Magic to nominate a director of the company pursuant to the nomination agreement ceased with what's described as the deed of release and the adoption of new articles. So this is a further denial that the right continues to exist. It's denial of the existence of the right.
It does seem, the passages we've looked at, there does seem to be an acceptance that the right was not just to nominate, but to have a director on the board.
My learned friend
just to make a suggestion,
yes,
but to have someone on the board.
Yes, we say that is obviously what was the intention, because otherwise, what was negotiated was nothing. What was negotiated was nothing other than the ability to say, would you mind considering this person, which anybody could do. Any shareholder could do. So it's on the judge's conclusion, it's a right of no content whatsoever. And the judge expressly says that, as I'll show you. And we say that that's what the judge failed to do, jumping ahead a little bit, what the judge failed to do is to test whether that was a commercially likely outcome. And that's before one even looks at the words in their full context with the factual matrix. And we think, I submit, that the judge seems to have done that because the judge appears to have begun his analysis by doubting whether it's an agreement at all. And so
Yes,
hence
no, it was just that sentence.
Yes.
In the premises, i.e. in the premises of him being appointed a director, the right of magic under the nomination agreement was fulfilled.
Yes, so I'm not going to take a pleading point against
No.
my learned friend and suggest that he's conceded my case. We've had the argument.
But there's an argument.
There is certainly an argument. I think my learned friend seeks to take a pleading point against the pleading here and says that we ourselves, I didn't plead it, I should say, but and I'll come on to why that's relevant because there's quite a lot of distaste expressed by my learned friend for the pleading. My submission is not fair. There's a difference of style, but that's not fair to attack in the way that we will see happens. But I'm not going to take the point that it's been conceded, that our interpretation's been conceded. But it does, I suppose, and this is perhaps the jury point, it does reinforce that there's clearly an argument here. And the suggestion that there's a hard-edged distinction between nominate and appoint is one that we say doesn't work. And then finally, on the defence, at paragraph 57, if I may, page 247, you'll see it's in the third sentence. In any event, by reason of the matters set out in section G above, any rights of magic to nominate a director of the company under the nomination agreement, which is my lady's point, have come to an end, and with magic's consent, it said. In the premises, it said, magic's right to seek the appointment of a director are to be found under the new articles and all the general law. So there is a clear denial within the defence that the right is of the sort that we say, or the content that we say. There's a clear denial that we're able to exercise it, because it said it's gone. I just noted that, because part of my learned friend's argument on his respondent's notice is to say that...
Never tried.
Sorry?
That you never tried.
That we never tried, or that there's no issue here. There actually is correspondence about that, which I may have to take you to. But the point is, and the judge, actually I should say, and on that, the judge said that's an evidential point on which he wouldn't be drawn in our submission, rightly so, because we're dealing with a summary disposal application. But what is absolutely clear is the position being adopted by Mr. Broadbent is that we don't have the right. Now, the appellate judge's decision is in tab 18. We're looking at the judgment. And if we can go to paragraph 42 at page 111. No, that's going to be wrong.
From judgment.
Tab 18 is the first instance judgment.
Yes.
It's tab
yes.
10, I think.
Thank you.
10, I think.
Thank you. The court knows the bundles better than I. Yes. Tab
And it was
10.
111, you said?
111, paragraph 42. And you'll see in paragraph 41, I should say, that having referred to the letter, which I'll show you in a moment, the judge referred to some other provisions of it. He said, I appreciate that none of those are directly relevant for determination of this appeal, but instruments, again, I hesitate to use the term contract, must be read as a whole. It does seem to me that clause 2 is coloured by the nature of the document as a whole and the other provisions contained within it. And you'll see that the judge then agrees with the ICC judge that clause 2 conferred no more than a right to nominate. And he says he thinks the judge was right. He then went further. Indeed, it seems to me the judge was wrongly generous to magic in construing this promise as anything more than a one-off. So on the appellate judge's view, my clients had negotiated something even less than nugatory right. Any person could propose a director, say, will you consider this person? But here we actually only negotiated that we could even make that proposal once. Now, and you'll see whilst we're here, in 42 Roman 3, the judge said that the nomination agreement simply recorded a right that Magic would have had in any event, namely to nominate a director whose name I'm prepared to accept would receive serious consideration for the company for the purposes of appointment, but only once, of course. I want to now turn to the document. It's in this bundle, tab 22. Page 223. This isn't a signed version. I don't think anything turns on that. Nobody's suggesting it wasn't an agreement. You've seen the defence on that. And it's paragraph 2 of this, MI, so that's Magic.
Sorry, can you tell us where it is again?
Sorry, yes, tab 22.
22, sorry.
Page 223.
Yep, thank you. Yeah.
Paragraph 2, MI, which is Magic Investments, will be entitled to nominate someone to the board. And as we've seen, the appellate judge seems to place some reliance upon the fact that there were provisions in the letter which were not contractual, such as, I think, paragraph 1, where it's describing what's going to happen. In paragraph 3, the statement the company does not require an audit in terms of the laws of England. And so the warranties are true and correct, although one might suggest that that is a warranty that the warranties are true. In any event, in my submission, what is clear and common ground between the parties is that paragraph 2 does have contractual effect, and so the need is to interpret that contractual provision. And it's, of course, necessary to consider the words used. The court will be pleased that we haven't, as is very common it seems these days, cited every case on construction. We take it as read that the court doesn't need any education on that. The words are nominate someone to the board. Now, in our submission, the natural meaning of those words, Magic will be entitled to nominate someone to the board, was that the nominee would become a board member. Let me say there's no difficulty with that at all. I should just note that it says Magic will be entitled. It doesn't say Magic is entitled. The language looks to the future, and we say that further supports the conclusion that it is a right which is continuing and may be exercisable from time to time. And we say that must make sense, because if it's right, if it's correct that Magic is able to nominate someone who is going to be put onto the board, it would be bizarre for that right, though, to be only exercisable once. One can think of all kinds of circumstances, including what happened here, where the person who's appointed decides for their own reasons that they wish to resign or retire, and then Magic has lost it. And you can posit other cases. What if the person dies in office and then Magic just loses the right? And as I've already made the point that the judge, perhaps influenced by his comments about whether it's a contractual document, didn't stand back and say, does this make sense that Magic would have negotiated something which gave it nothing? That it was merely an entitlement to express a view, to do that which it could already do, effectively to express an opinion. And we say it would be objectively, commercially implausible, even nonsensical, to insist upon such a nugatory provision. It gives it no content.
Do you make anything out of to the board?
Yes, I was just going to say.
Yes, no, precisely. It's to the board. We say and this is my learned friend makes a big distinction in his in his skeleton between the words nominate and appoint, but it's the full words nominate to the board, and we say that that is making clear that it's something that goes further. Nominate. It doesn't say nominate someone who shall be considered, but it's nominate someone to the board. We say in context what those words mean is to have somebody on the board. And we say that that's clear from the words used, the commercial logic of it, and that's before we then look at the relevant factual matrix, which I'm just going to briefly show you the material on that now. And one of the oddities about this case is that the application was made very late, summary disposal, and heard 4 weeks or so out from the trial. was going to be a 4-day trial. I think by the end of this, we would have spent nearly 4 days full time. So it's unfortunate that we are where we are, but we are where we are. The consequence was that by the time of the hearing before the ICC judge, we had the witness statements for trial. Can I ask you to look in supplemental bundle 1? Volume 1. And paragraph 46, sorry, tab 46. This is the witness statement of Mr. Lazarus, who you can see from paragraph 8 is the chairman of Magic. Could I ask you to turn to page 259, paragraph 7? You'll see he explains that Magic was incorporated in Luxembourg with the purposes of holding all foreign investments on behalf of RAM. That's defined as paragraph 2. It was the RAM group. Which Mr. Lazarus is the executive chairman. And he explains in paragraph 8 that Magic is that Magic has 6 overseas investments, one of which is its investment in the Greater Good Brewing Company, Greater Good Fresh Brewing Company Limited, so the company. And at paragraph 9, he explains how in 2018 he was introduced to Mr. Mayer, who was then at Investment Bank, and he explains in paragraph 10 that there was a possibility in 2020 that Mr. Mayer was going to become the CEO of Magic, so of my client. And over the page at paragraph 11, it's explained that Mr. Mayer was already himself a shareholder of the company, of TGG, and he proposed that, or seems to have discussed with Mr. Lazarus, an investment in the company as a potential investment. And you'll see paragraph 12, Mr. Mayer introduced Mr. Lazarus to a Mr. Arrowsmith and a Mr. Bergman and a Ms. Gribben and a Mr. Wicht, or Jason, all of Investec. Investec was the bank which was seeking to raise funds on behalf of TGG, so on behalf of the company. Paragraph 14, he explains that Magic received an investment pitch deck from Investec on behalf of the company. Paragraph 16, he explains that at the time, we, so that's Magic, were only communicating through Jason at Investec, who in turn would revert to Mr. Broadbent to obtain specific information or documentation. Ralph was a director and majority shareholder of TGG. It does explain in paragraph 17 that they did have a direct call with Mr. Broadbent, a conference call. Now, paragraph 20 over the page, it's explained that Magic's investments have to comply with the South African Exchange Control Regulations, called EXCON, which includes specific allowances and restrictions on various types of transactions involving foreign currency and foreign direct investments, FDI. Paragraph 21, the Financial Surveillance Department of South African Reserve Bank is responsible for daily administration of EXCON. And you'll see in paragraph 22, pursuant to the approval of RAM's first investment by the South African Reserve Bank, one of the key requirements required by EXCON is that if an investment represents a shareholding of 10% or less, you must have secured representation on the board of the company in which you're investing. So, as such, if Magic invests in any company with a shareholding of less than 10%, a board seat must be provided in lieu of the minority shareholder take-up. And he says in paragraph 23, we explained the absolute requirement of a board seat to Jason ad nauseum. So just pausing there, that's Magic's evidence. Magic's position was it needed a board seat. Magic communicated that to Jason, who was acting for Investec that was dealing on behalf of the company. So that's Magic's evidence. I'll briefly show you the company's evidence. Sorry, Mr. Broadbent's evidence, I should say. Mr. Broadbent's witness statements at tab 50. If one goes to paragraph 13, which is page 307, he says, David Lazarus, whose witness statement we're looking at, indicated that Magic would be interested in making an investment, but wanted Chris Mayer to be on the board. That suited us well, as Chris seemed like a great fit. The company needed to step up in management, etc. We therefore agreed. I recall that Magic asked me to confirm in writing that I would approach Chris to join the board, which I did. So that's his evidence. That's the totality of about the evidence in relation to the origination of the letter. No reference there to the South African controls, no reference to any of the discussions about it. It doesn't even expressly explain, refer to the nomination agreement. Mr. Dixon, who's the co-founder, also gave evidence in a witness statement or tender witness statement. That's in the previous tab, tab 49. He says even less. If one goes to paragraph 19, page 299, I ask you to read that. No reference at all to the nomination agreement. In fact, reading that, one would get the impression that there wasn't one. There's no details given about its origination. Now, given that this was a summary disposal in our submission, it's quite clearly not possible for the appellate judge to have rejected that evidence that you've seen from the company out of hand on a summary basis. And of course, he didn't purport to do so. Rather, the judge's judgment didn't make any reference to this at all. In our submission, in so doing, the judge erred. My learned friend's skeleton argument for the appeal likewise makes no reference to this factual matrix background, which we say is relevant. Because even if one needs more than looking at the words used in the agreement, in my submission it's clearly more than fanciful, and we'd say actually it's clearly right, but having regard to the factual background known to the parties that Magic required a board seat, that one reads it to mean exactly what Magic says it means. I should say, I mentioned earlier about the correspondence that, that Lazarus, Mr. Lazarus, has indeed been consistent about this position. I'm just going to show you, if I may, just a few emails. This will also speed up how I deal, in due course, with the respondents' notice points. I think you have open Supplemental Bundle 1, which is the right one. Could we go to tab 12, please? At page 107, midway down, you'll see an email of the 18th of October 2021. This is after Magic has invested. This is in the context of proposals to retire the existing articles and the existing shareholders agreement. And you'll see that Mr. Lazarus sent an email to Mr. Broadbent saying, thank you for the details mail. Question of how the Magic board seat will be dealt with following our last discussion. Clearly, believing and persisting in the view that Magic has a board seat. The response from Mr. Broadbent is at the next tab, tab 13. Same day, at the bottom, he said, "Hi David, I know you were keen to have a chat with some on the board, must be someone on the board, on the back of the US thinking. More pertinent to the next paragraph. In terms of the board seat, I was up for you appointing Chris because I felt there was tremendous value add to the company and it was a relationship that could work." He then goes on, essentially to say, "I'm nervous about offering another appointment because we have only 4 precious seats and I want to make sure that we have the right blend of expertise for 2022. So this is, I'm nervous. This is Mr. Broadbent saying, I don't really want to do this. Now there was a response to that at tab 14. This is the next day, 19th of October 2021, from Mr. Lazarus. "Hi Ralph. When we invested at the time, it was a clear request and agreement that we would have the seat at the time occupied by Chris. No independent director is acceptable, as this is a requirement from the Fiscus," I'm assuming that's the Financial Surveillance Department, or something similar, in SA, South Africa, for the overseas investment at the time. At tab 16...
Sorry, could you read the last sentence?
"My learned friend wants me to read out, happy to chat to Hugh, but in view of the fact you are redefining the board, I think I should speak with the new board once this process is completed." My learned friend is suggesting that my clients gave up their right. That's mission, that's hopeless. We go to tab 16.
16.
16, 16, page
Sorry.
112. The bottom of the page, you'll see on the 24th of October, I think we've only got an extract from it, but there's an email from Mr. Da Costa, also of Magic, who wrote to Mr. Lazarus and Mr. Broadbent, following on from David's comments, "Please see the letter of March 2021 confirming Magic is entitled to nominate someone to the board." So clearly making the assertion, being persistent and consistent. And Mr. Broadbent's response at the top, "I don't think there's any question that you were able to nominate someone. The issue is that I think you now want a second nomination." He goes on to say, essentially, that it's a matter for him when I'm choosing the board. You'll see that in the 3rd sentence. And then he says, "What is more tricky for me is to agree to an appointment that doesn't fit into the wider context of the board. Each seat should offer skills that complement the others to give optimum value add. Ideally, I can find a board makeup that you're happy with, but I really think the priority needs to be the best possible board to give the business the best chance of success by allowing shareholders to make ongoing appointments indefinitely." So clearly pushing back at the suggestion that Magic had this right and reinforcing that it was him. He was the one who considered that he got to choose. He was the person behind the decisions. I think the final document is at tab 19 that I wish to show you, 19. And it's an email, again from Mr. Broadbent, 25th of October 2021, to Mr. Lazarus. Says, "I've been looking back over the correspondence we had around the board seat, keen to find a solution that works with everyone, as well as to get to the bottom of what was originally intended." And then next paragraph, "The letter provided by Alan shows that we agreed Magic would have the right to nominate someone to the board. In your most recent emails, you are now suggesting that you then have the ongoing right to a board seat, which I don't think the original letter provides for. The board nomination isn't an appointment, and I can't see any reference to that leading to a second nomination after the first one." And you'll see, you can read the last paragraph. So essentially putting forward the case that's advanced in the defence. Not a right to have someone on the board, and it's only right to make effectively a proposal once. But there's a slight tension there, because if you're able to make a proposal, why could you only make a proposal once? Now, Mr. Broadbent puts great emphasis upon the difference, he says, between the words nominate and appoint, which is in my learned friend's skeleton argument at paragraph 40. The first point, I've already addressed your point, it says nominate to the board. That's different from nominate someone to be considered for appointment. Second point is that the agreement is to be interpreted against the factual matrix and the understanding communicated by Magic that it required a board seat. The third point, even divorced from the factual and commercial context, in our submission, the words appoint to the board can clearly have the meaning that my client contends for. I want to just show you something on that, because there appears to be the suggestion that appoint and nominate are defined words that have some independent meaning, as opposed, which somehow governs this question. In my submission, no. Can I ask you to look in supplemental bundle 2, tab 67. What we have here are the model articles promulgated by the British Private Equity and Venture Capital Association. These form the template for the new articles that the company ultimately adopted. If I could just ask you to turn to page 504, Article 28. An article called Appointment of Directors. It provides in 28.1, in addition to the powers of appointment under Article 17.1 of the model articles, each investor, for so long as it's a permitted transferee, etc., shall be entitled to nominate one person to act as a director by notice in writing addressed to the company from time to time. And the other holders of shares shall not vote their shares so as to remove that director from office. So these are specifically drafted provisions, and you can see in there it's implicit that the draftsperson considers that if someone is nominated to act as a director, that is the same as having them appointed, because that's what it then goes on to say they shall not vote their shares so as to remove that director from office. I'm not suggesting that these inform the interpretation of the letter, but I just use this to illustrate the point that this hard-edged distinction that Mr. Broadbent seeks to advance is one that doesn't really stack up. The new articles were adopted by the company as from the 1st of November 2021. I ought to just show you that. It's in Supplemental Bundle 1, tab 23. If we go straight to page 146.
Sorry, I must be in the wrong.
Supplemental Bundle 1,
Yep.
tab 23.
Thank you.
First, we've got the resolution, and then they start at page 121,
Thank you.
and it's page 146. And you'll see the formulation that was eventually adopted by the company, Article 24.1, in addition to the powers of appointment under Article 17.1 of the model articles, each founder, so that's Mr. Broadbent and Mr. Dixon, for so long as he and his permitted transferees holds any of the shares in issue, shall be entitled to nominate up to 3 persons, including himself, to each act as a director, by notice in writing addressed to the company from time to time, and the other holders of the shares shall not vote their shares, nor shall their co-directors vote pursuant to Article 25B, so as to remove such founder directors from office. So the wording adopted ultimately uses the same sort of concept. And so ultimately we say nominate to the board can and does have the meaning given to it by my client. And we say it's certainly more than fanciful that that issue would succeed at trial. And it might be that the court thinks that it's the right answer. But I don't need to even go that far, submission for the purposes of today. I should address one part of the appellate judge's reasoning. It appears that the judge was in part informed by his observation that the power to appoint a director is generally not agreed bilaterally between a company and one shareholder. That was paragraph 42(3) of the judgment. Mr. Broadbent didn't pursue any argument that the agreement wasn't effective in law. You've seen in his defence he actually admitted it's an agreement. His arguments about the interpretation. He didn't argue below that therefore this agreement didn't have any effect. He doesn't in his skeleton argument make reference to or seek to support that aspect of the judge's reasoning. The judge didn't cite any authority for it. And in fact, what the judge said, sorry, I probably ought to show it to you. It's in core bundle, tab 10, page 111. 42, Roman 2. Having accepted in the previous paragraph that the right to appoint a director is a significant right, he says it's one that matters, is because of the significance of such powers, power to appoint is not generally bilaterally agreed without the involvement of other shareholders. He says it seems to me the judge was right to consider that a right in a single shareholder to appoint a director would have to bind all shareholders either by way of the articles or in a shareholders agreement. It said no authority was cited below for that, nor here. My learned friend doesn't seek to support it, and he accepts, his client accepts it's a binding agreement. But what the judge then went on to say is, otherwise there is a questionable preferring of one shareholder, here Magic, over all others. Well, in my submission, that might be an issue as to whether the company should have agreed to it, but the company did. And of course it did it to induce my client's investment. And I would just note this, of course. One might have a shareholders agreement with the original shareholders which sets out the right for them to nominate to the board. Actually, that's what we do have here. A new shareholder might acquire shares, but might not sign a deed adhering or acceding to the shareholders agreement. Would it be said that suddenly this right is gone? My submission, that's not likely to be the outcome, but we don't need to resolve it because nobody is seeking to uphold it. So in my submission, it is the case that Magic has, at the very least, a reasonable prospect of success in relation to the scope of this agreement. And the judge was wrong, the appellate judge was wrong to have concluded otherwise. My learned friend then raises a number of points on the board seat allegation by way of respondent's notice. And at this, we address those in our supplemental skeleton, which is the document that has made its way to you from April. We addressed it in paragraphs 19 to 22. At this stage, I'll just make 3 points, if I may. First, there's a suggestion in the respondent's notice that the right was not denied. The judge, in our view, quite correctly took the view, this is at paragraph 42.5, which I think you have in front of you, that this is an evidential matter on which I'm not going to be drawn. Quite clearly, not a matter for summary disposal. And I've shown you communications about that, and I've shown you the defence, where Mr. Broadbent specifically repeats the denial. The second point in the respondent's notice is a suggestion that this is a trivial complaint. Well, again, that is contrary to the view of the appellate judge you've seen in 42.1. You rightly recognise and place reliance upon the fact that the right to appoint a director is a significant right. It is one that matters. And we say that's quite clearly the case. Having the ability to have influence on the composition of the board is a right that's of value. That's why we have, if needs be, I'll show you authorities, why it's quite common for a company for somebody who's been denied a right of participation in management in a company to be able to obtain this sort of relief. And here, of course, Magic specifically required it for the reasons that I've shown you. So my submission, the idea that this is trivial, when it was quite clearly a basis and prerequisite for the investment, is a hopeless argument, which to be raising on a respondent's notice.
But it's a point that Mr. Broadbent himself was making in his letters in response, isn't it? He was saying, it's important to have people who will all work together and who bring different skills, and I mean... Absolutely.
There could be no suggestion that the composition of the board doesn't matter, and the suggestion that you have no ability to influence the composition of the board is something that's just trivial when you negotiate.
Because one director may persuade others.
Quite. There was a suggestion, I'm not sure if it's being pursued now, there was a suggestion, well, because any director appointed to a company owes duties to the company, then you can't complain. The first answer to that is, well, if that were right, then you'd never be able to rely upon being excluded from management.
You'd never need a diverse board.
Yes, you'd never need a diverse board. And also there is further authority which we've got here, which makes the point that a director who's been nominated can, whilst the primary duties obviously to the company, have regard to the interests of the appointer. I'm not sure the extent to which that's being pushed, but it would be novel to say the least if it was being suggested that denial of a right to have someone on the board actually isn't something that can justify unfair prejudice relief, because then quite a lot of cases have been decided very wrongly indeed. Third, there's a suggestion that the adoption of the new articles overtook the nomination agreement. Neither the ICC judge nor the appellate judge reached a decision accepting that argument, although it is right to say that at paragraph 44 of the judgment, in two sentences, the judge said, additionally, it is very difficult to see how the right contended for by Magic could survive the rearrangement put in place by the deed of discharge and the new articles. One would expect a specific right of appointment to be dealt with in the articles. So far as that second sentence, that's the judge's...
Sorry, where is that second sentence?
It's in paragraph 44, tab 10 of Core Bundle, page 112.
Yes.
This is going back to the judge's, in our submission, incorrect view that it needs to be in the articles. And in any event, in my submission, the judge was right not to decide it on this basis. I'll have to see how my learned friend puts it. It's only addressed in one paragraph of his skeleton argument. He doesn't identify what doctrine he relies upon for this. There has been some... My learned friend will forgive me if I say shifting on the doctrine. The defence at paragraph 33, which is in the Core Bundle at tab 24. Page 242. Said, in agreeing to the deed of release and the new articles, Magic implicitly accepted that. And then the first thing is that the agreement to amend, which is an allegation we're not being pursued, fell away. And secondly, again, we don't have to worry about that, it's the third one, 33.3. By reason of the matters set out above, and in particular the terms of Article 24 of the new articles, the restrictions over founders' loans and the nomination agreement also fell away. Now, the way it was ultimately put on behalf of Mr. Broadbent before the ICC judge was to contend that there had been an implied rescission of the nomination agreement. We've made the point, which we did argue before the appellate judge as well, that the deed of release doesn't purport to affect the nomination agreement. And I think that's might be why my learned friend's skeleton argument doesn't itself rely upon the deed of release. It's essentially now relying upon the fact that new articles were adopted. As we've pointed out, and as we argued before, an implied rescission requires to establish quite a high burden. And we've cited an authority which my Lady Justice Asplin, I think, will be familiar with, which is Frango and Frangos, in which my lady was one of the panel, where Lord Justice Snowden, as he then was, set out the test. You've got to show that the second document is fundamentally inconsistent with the first. I'll have to see what my learned friend puts it, but we say it's absolutely impossible to make that argument here.
Just on that.
Yes.
I'm trying to remember what I did look at in the pre-reading. Frango and Frangos is 2023, and I think Lord Justice Snowden relies on Cobalt in the Court of Appeal. Well, Cobalt went to the Supreme Court. I'm not sure they said anything vastly different, but if we're into this territory, we ought to look at what the Supreme Court said.
Yes, I believe we did actually, and we were, because we noted that before we argued it before Mr. Justice Marcus Smith, and we didn't think it had changed things. But we will, of course, look at that. As I say, I'm not sure how my learned friend is going to put it, and it may be that this is not now how it's being put, because he doesn't refer to these doctrines at all in his skeleton argument. So, well, I'll turn then, if I may, to the pure dilution argument.
Just before you do,
Yes.
while we're in the authorities,
Yes.
I did notice the Singapore case,
Yes.
wellness. I don't know if it's mentioned in the skeletons, but obviously it's been identified as potentially relevant.
Yes, we cite it in our supplemental skeleton argument at paragraph 17b.
I've forgotten that.
This was quite an interesting decision. This decision of the Court of Appeal in Singapore. What had happened is that there was a shareholders agreement, and I think a joint venture agreement. Perhaps we could look at it. It's tab 16, the Lord's mentioned.
Tab 16 of the authorities.
The authorities bundle,
Yeah.
yes. Page 371. It begins in paragraph 1. It is commonplace for shareholders' agreements and joint venture agreements to contain a provision entitling a shareholder to nominate or appoint a director to the company's board of directors. This may be so even where the constitution of the company confers the power to appoint directors upon the board. And what you'll see in paragraph 2, in about the third sentence, the respondents claim that the minority shareholder has a mere right to nominate a person for directorship, and that the board of the company retains a discretion not to appoint that person if it would not be in the company's interest to do so. Central to the appeal were the questions of whether contractual term obliges the company to accept the shareholder's nominee or appointee. We don't need to go too far into this. What had actually happened in this case is there had been an earlier decision where it was held that there was an implied term into the shareholders' agreement. And I'll explain what that term was. If the court looks at paragraph 4, the shareholders' agreement in that case provided board of directors In 5.2, composition, the board shall comprise 2 persons appointed by Paris and Wellness and 1 person appointed by OSIM. This had presupposed, I believe, that Wellness was going to be a majority shareholder and so would have the ability to appoint 2 directors. There was an implied term, this is paragraph 7, because it admitted to address the situation where Wellness, whether by itself or with Paris, ceased to be the majority shareholders. And the specific term to be implied was that the majority shareholders, whoever they may be, would be entitled to appoint 2 directors, and the minority shareholders would be entitled to appoint 1 director, so long as they hold at least 25% of the shares in TWG. That was an implied term. The question was about the scope of that implied term. And at paragraph 34 at page 378, actually, paragraph 32, I should say. The last sentence, but the respondent's interpretation, which requires Wellness to persuade the respondents of the suitability of its candidate for its nomination to be accepted, would practically render the implied term redundant. In paragraph 33, for the reasons we set out below, we hold that the implied term gives Wellness a right to nominate 1 person to be a director of TWG with a corresponding obligation on the part of the board to appoint that nominee as a director. And is part of the reasoning, you'll see it paragraph 34, it is clear...
Just before you go on to 34, I mean, they add 2 caveats.
Yes.
So one is, well, the person's disqualified, which
yes.
seems a fair caveat.
It does.
The other one wouldn't be obliged to appoint if it's established that the person would be obviously unfit for office or that his appointment would be obviously injurious.
Yes.
No, that we're not in that territory here.
No.
Could there be a similar qualification in terms of your construction of the nomination agreement, or don't we need to worry anyway, or what?
Don't need to worry anyway, because that's not the argument. If we were to have that argument at trial, maybe we could have, but because the denial is you have no right.
Yes.
So the specific scope of it is different. You'll also note, my lord, that they went on to say the burden is not on Wellness to positively establish the suitability, but upon the board to prove its unsuitability. So that's the way it would work.
Yes.
In their view.
And then 34, which I can quite see why you like.
Yes. It is clear the implied term must confirm more than a mere right to nominate with no corresponding duty to appoint. It would be redundant otherwise. Commercial purpose. The implied term is key to its interpretation. And it goes on along. There's more of that in paragraph 35 as well.
The issue right now is whether the letter confers the right and what nominate to the board means. But at some stage, the scope of that, if it's demonstrated that there is a right, then the scope does become important.
Yes, it does, save for this, because it's been denied that we have any right at all. So we don't have the right to have anyone on the board. It's not being said, tell us who you think, because you have that right.
Yes, it's not that you've nominated somebody and they said we don't like your someone because they won't fit with us. That's an argument about scope.
Quite.
But at this stage, it's only about whether you have the right to have someone
yes.
on the board of your choosing.
And test it this way: if we were to nominate your lady, my lady, they would say they've no right.
Yeah,
that's what they say. That's their defence.
Instead of saying that it would be positively injurious.
I didn't finish the sentence.
You didn't need to.
My lady, they wouldn't satisfy the burden. Now, although I don't know what experience the court has of home brewing. I'll move on then. Dilution.
Pure dilution. Yep.
On the subject of liquids. The pure dilution allegation. So, given where we've reached, what I propose to do is this. I want to just address the judgment and show you the evidence. And then show you how the argument was put. And then I'll address you briefly on the way it's pleaded. And then we'll see probably then have to hand over to my learned friend and then see what he says. But I want to give you the highlights and rather the shape of the argument. The judgment is in the core bundle, tab 10, page 99. Or we can go straight to paragraph 7, page 102. I'll ask you to read paragraph 7, please. Thank you. In paragraph 8, the judge summarised the arguments. Paragraph 8, Roman 1, the board seat allegation. Paragraph 2, what he calls the failure to amend allegation. In paragraph 3, there has been unfairly prejudicial in the issue of new capital by way of share offering to existing shareholders, which included the conversion of the founder loans into equity. The matters complained of are those described in section D above, which is the paragraph I just asked you to read. And I shall refer to this allegation as the dilution allegation. The dilution allegation has two aspects, one which is linked to the failure to amend allegation, and the other which stands independently of it. And if one goes then to paragraph 32, this is where the judge, the appellate judge concludes that the argument, so far as it relied upon obligations under the subscription agreement, the failure to amend, has fallen away because of the new articles and the new deed and the deed of retirement, I suppose. So he therefore said that was the complete answer to the failure to amend allegation and to the dilution allegation, to the extent that this allegation is related to the failure to amend allegation.
Sorry, where are you?
Paragraph 32, page 109.
Thank you.
And so at the end of the main paragraph, 32 said, I therefore dismiss these two grounds of appeal, leaving for further consideration, 1, what I shall call the pure dilution allegation. Yet this allegation of unfair prejudice contends that altogether independently the failure to amend allegation, Magic was unfairly prejudiced because the offering of additional shares was at an undervalue in circumstances where the holders of founders' loans were advantaged by being able to convert those loans into equity, such that Magic's shareholding was improperly and to Magic's prejudice diluted. He then addresses it in section K at the bottom of this page. See paragraph 34. Although the company contended that the petition was against Mr. Broadbent and not the company, and that Mr. Broadbent, as a minority shareholder, could not act to prejudice Magic in the way pleaded in the petition, it seems to me that it would be an error to decide this point of appeal on an arid technical ground, which, even if correct, can easily be corrected for. This actually foreshadows one of the, I think, one of the respondents' notice arguments where there's at least a pleading complaint that it doesn't say words to the effect of Mr. Broadbent was therefore involved in the following matters. Then paragraph 35, I am also going to proceed on the basis that the offering of additional share was at an undervalue, in the sense that had there been an offering of shares to persons other than existing shareholders, the offer price would have been higher. So that's essentially saying that it was offered at less than market value. The use of the term undervalue is in such a case something of a tendentious one. What the company was doing was seeking additional funding from existing shareholders on terms advantageous to those existing shareholders. Can I just ask you then to read paragraph 36? And then paragraph 37, the judge said that the fact that the founder loans were converted doesn't make a difference. it's accepted by Mr. Broadbent that this reasoning is incorrect. And he makes the point that it wasn't argued on his behalf before the appellate judge. It was a somewhat unfortunate situation where the original draft of the judgment didn't address the pure dilution argument at all. I'll show you, because it goes to my learned friend's new pleading points, that the judge was asked to address it, and he addressed it in these terms. And we submit that it was clearly wrong. I need to show you then, just briefly, the decision in Petty and Thompson Petty Tube Products Limited, which is in the authorities bundle, tab 9.
Decision of the Outer House.
Yes, it is. There are some English authorities which we've also got in here, but I don't think there's any dispute that the law as set out here is correct. If I could ask you to look at Lord EC's judgment at paragraph 17. And you'll see that what had happened, that there'd been an allotment of shares. And in paragraph 17, it said, in the present case, the purpose of allotment was to raise further capital. It had been done by issuing shares at par in order to reflect an existing practice in the company. Counsel for the respondents went on to submit that there was no authority to the effect that issuing shares at par when they were worth more constituted unfairly prejudicial conduct. And at G, you'll also see it was said that the petitioners had been invited to subscribe at par, as were all the other shareholders. If there were prejudice arising from the disputed allotment, that in turn stemmed from the petitioner's decision not to subscribe. Paragraph 20. It is, I think, evident that the issue of new shares at a price below their true worth will reduce the value of existing shareholders unless that shareholding is increased pro rata by addition of new shares at the issue price. And there's an example given, which I don't think we need to go into. Paragraph 21. It is accordingly understandable why the practice of issuing shares in undervalue is seen as being prima facie a breach of the director's fiduciary duties. And there's a reference to, which we've got in the bundle here if we need it, Lowry, Lord Wright, where it was said at F, if the share stands at a premium, the directors prima facie owe a duty to the company to obtain for it the full value which they are able to get it. It is true that it is within the powers under the Companies Act to issue it at par, even in such a case, but the duty to the company is not to do so unless for good reason. And then over the page, paragraph 24, having sort of set out the facts, so in these circumstances, at the bottom of the page, I have little hesitation in reaching the conclusion that the disputed allotment was indeed prejudicial to the petitioners, who did not subscribe to the new shares, by reason of its having the effect of materially reducing the value of their holdings, to the corresponding advantage of the respondents who bought the new shares at a price below their proper value. The directors were thus, at least prima facie, in breach of their fiduciary duties. And relevantly, in paragraph 28, he addressed the argument which was that the disputed allotment was not unfair, since the petitioners had been treated equally with the other shareholders in that they had also been invited to subscribe for new shares. The prejudice suffered by the petitioners arose because they had chosen not to accept that invitation. And the judge disposed of that at paragraph 30. Over the page. Whereas here, minority contests the allotment of new shares at a significant undervalue, an insistence on the part of the directors and the majority on proceeding in that course, rather than, say, offering new shares at a price reasonably reflective of their true value, amounts effectively to a course of coercing the provision of further funds under the threat of that minority as being penalised by suffering a relative diminution in the capital value of their holding. And as I'm going to show you, in the evidence here, the company said itself, or those supporting Mr. Broadbent said themselves, that the price that they were offered these shares at was partly to coerce more money from shareholders for fear of dilution. Now, it's in light of this that we say that the appellate judge's reasoning, with great respect for disposing of the pure dilution argument, was wrong. And as I said, my learned friend accepts that. As regards the evidence, I can deal with that quite quickly by looking at a few documents in Supplemental Bundle 1, beginning at tab 24. It's an email from Mr. Broadbent, 30th of March 2022. Hi chaps, we've had an approach from Brewdog, the largest craft beer brewer in the UK, to take a major stake in Pointer. That's the product. There's a lot of work to do, but broadly this is how it looks. You'll see there's a description, small cash payment, possibly 5 million. It require 40% of Pointer using Brewdog shares. We'll get an uplift in value because they're paying in shares, not cash. My target for this would be to get a £100 million valuation. They would definitely do at least 56 million. We just need to negotiate, which we haven't got into. So just pausing there, the proposed, what was on the horizon was a deal where the structure of the deal was assuming that the company might be worth at least 56 million or possibly 100 million pounds. We can jump forward then to June. This is the end of March, so June that year, at tab 27. It's an email of the 17th of June from Mr. Broadbent. This is a shareholder update, so it's sent, I think, to all shareholders. Hence, it's entitled Dear Investors. You'll see that there's discussion of the Brewdog deal. Progress has been painfully slow. Brewdog have sent us their final legally drafted detailed heads of terms which we are reviewing. So just pausing there, the deal was clearly still on the horizon. They had detailed heads of terms. However, we must be realistic that if we carry on down the current path, there is a material risk that the deal will not complete, as is the case with any transaction. And it's said that our investors, our advisors, Investec, are of the view that this deal would only likely complete sometime between the end of July and September. So we're talking about in the next 4 or 5 months, I suppose. There's reference there that there'd been a speed bump referring to Project Easter. It appears that there was a new version of the product which there had to be a product recall, so there was an issue, I think. And it says in the last sentence of this page, we now find ourselves in a position where we have 4 weeks cash runway and we need to make sure we secure our future. And then over the page, there is a proposal. And at the first bullet point, the mechanism to achieve what I've set out above is a share issue of 6 million shares at a 6 million pre-money valuation. Investors who have the right to buy shares in proportion to their shareholding. Investors who take up this right shall have their percentage shareholding preserved. But where investors don't participate, shares are effectively diluted to 50% of their previous shareholding as a percentage of shares in issue. This is because we've doubled the amount of shares in issue. Paragraph 5. The issue price was going to be £1.04 per share. And then the next paragraph, I want to stress that we are not saying that this is what the company is worth. Indeed, the Brewdog heads of terms place a valuation at 56 million. This is a mechanism to encourage as many shareholders as possible to participate in this round. These shares are only available to existing investors and is a mechanism to get the company back in the driving seat. As part of this raise, there is a total of £2 million possible debt conversion, leaving a total cash inflow of £4 million. The board believes that £4 million cash is the minimum cash that we need to see the business through to positive EBITDA. Now, as is clear from this, they were not saying that the issue price was based upon an actual valuation of the company. And they were specifically referring to the Brewdog heads of terms placing the valuation at 56 million. They were specifically saying that if you don't take this up, you're going to be diluted. Magic objected to the transaction. It went ahead. I don't think we need to go into too much of that correspondence, but just a couple of documents, if I may. Tab 32. We have an email exchange between Mr. Da Costa of my client, Magic, and Mr. Broadbent. It's in multiple colours. The black, I think, was Mr. Da Costa's original email. Red is a response that came back from the company or its lawyers. Purple is Mr. Da Costa's further responses to it. All I wanted you to note is that paragraph B1 on the first page, so 1B1 and 1BB1. In the purple text, Mr. Da Costa said, it is of extreme relevance, not only to us, but to all other shareholders. This is the fact that some of the shares were going to be paid by converting debt. Even on your own version, the proposed transaction does not bring in £6 million. We are being requested to follow our rights, while the loan shareholders are in fact not bringing anything to this new round other than the conversion of their loan.
But also conversion of their loan into a disproportionately high number of shares, given the valuation.
What? They were able to buy shares
At an undervalue.
That's an undervalue. And as I'm going to show you what their evidence was about this, because for the trial. And in fact, if you go over the page, paragraph 14 at the top, by attempting to convert the loans to equity in this round.
I'm sorry, I'm not sure where you. Oh yes, I am sure where you.
Apologies.
Thank you.
Apologies, my lady.
Got it.
Yes, the numbering is
Yeah.
not easily navigable. By attempting to convert the loans to equity in this round is not only in breach of your undertaking given by you in the magic letter, but it is in complete bad faith. We can ignore the magic letter for now, that's fallen away. But it's in complete bad faith, given that according to your proposed scheme, shareholders not following their rights will be diluted 50%. And then on the last page of this, there's a conclusory paragraph. I'm not an expert on the English Companies Act. There's reference to unfairly discriminatory or unfairly prejudicial conduct. We are of the view that this proposed resolution scheme is both discriminatory and unfairly prejudicial to ourselves and other minority shareholders. Asked for an undertaking that it wouldn't happen. The company went ahead anyway, but I just want to show you what the company said in a response at the next tab. This is from a Mel Sims of DWF, so the company's lawyers. And can I just ask you to note that, so the first paragraph, Ms. Sims refers to the email, which I think is the one we've just been looking at. And then it's the third paragraph, last two sentences. The offer was never designed to raise 6 million in cash. It was designed to raise up to 4 million in cash and enable a capitalisation of loans in relation to the basic entitlement of qualifying shareholders not exceeding 2 million. So the company is saying only trying to get in Form 6. Now, the evidence actually, I want to show you one more letter. Tab 34. It's an email. It's a letter. At page 191. No, it is an email. This is an email from Mr. Lazarus on the 25th of June back to Ms. Sims. And it's just the penultimate paragraph. For clarity's sake, this scheme of arrangement is concocted solely to protect the equity of the founders, as the capitalisation of their loans, which are not due, payable, in no way assist the company with the cash flow requirements required. We'll take you now briefly to the company's evidence. Mr. Haslam, who is the chairman of the company, filed a witness statement. It's at tab 48. So this is in support of the, or opposition to the petition. This is a trial witness statement. If we go to paragraph 21.
Sorry, tab again.
48, my lady.
Thank you.
And in paragraph 21, under the heading the rights issue, he discusses this product failure. Says this put the company under significant financial strain. The company needed a significant injection of funds. That would normally mean cash. Although the company was in discussion with Brewdog, etc., there was no guarantee that such a transaction would in fact take place. It then says that those were subsequently discontinued, but not until after this had all happened. Investec was advising the company. After much deliberation, the board concluded the company should seek funding from existing investors in a funding round, which became known as a rights issue, and that this rights issue should be at a discount to what was perceived to be the market price of the company. So their own evidence it was at a discount to market price, to provide an incentive to all shareholders to participate in the funding round. Such discounted rights issues are not uncommon. My recollection is that the initial suggestion for rights issue came from Ralph Broadbent, but the board carefully considered other options. And you'll see about midway through this paragraph, my own experience and that of other board members who had commercial experience elsewhere was the balance of carrot and stick. Sorry, I should actually read the previous sentence. I do apologise. We considered that this would be the most appropriate route to take to raise the required investment, as it balanced a commercial opportunity, buying shares at a price below the level indicated by the discussions with a major commercial enterprise, and the needs of the company for a stronger balance sheet, with the threat of dilution for investors who chose not to invest. My own experience, etc., was that the balance of carrot and stick could be very effective in closing a funding round. Just the company's own, or the evidence filed by Mr. Broadbent was this was less than market price. They were trying to coerce. They were by the threat of dilution. Carrot and stick. Stick. What is stick? But coercion. Now, in a normal case, one might need to infer that a share issue was at a particular price under threat of dilution in order to coerce investment from those who didn't want to take it up or put it in. However, here it's positively admitted and being put forward as what was behind the intention. The issue price was not calculated by reference to some actual valuation of the company. We say this is clearly more than capable of giving rise to unfairly prejudicial conduct. I want to also show you Mr. Broadbent's own evidence at tab 50. Same bundle.
One might say that it's possible that the reverse was true because they were getting in more capital, partly because there's reference to the potential for insolvency because of the product recall, etc. So the on the face of the evidence you've shown us, they're saying it's at a discount, but it's in the balance.
And we say that that would be a matter for trial.
Yeah, that's what
Yes.
I'm saying. That
No,
you can't tell.
I'm not asking you to determine
No.
the trial. I'm saying that we should have had the trial, or we should still have the trial, particularly given the
Commercial
evidence.
necessity and threat of insolvency wouldn't explain the founder's loans aspect of this.
The point I'm coming on to the extent there is an attempt, because clearly they do try to justify the rights issue, but the justification itself clearly gives rise to a triable issue, because I'll show you it and then I'll make the point. So Mr. Broadbent's evidence is at tab 50.
But what I was saying was,
Smiley.
basically, what you've shown us refers to a discount.
Yes.
And the question of whether there was or wasn't and the extent of it is a matter of evidence.
Yes, and in fact, so what we've got is the contemporaneous email that we saw where they say, firstly we say possibly 56 million or 100 million. Then they say, we're going to do it 6 million. We're not saying it's what it's worth. In fact, we've got a 52 million valuation deal on the horizon. There's no suggestion, as you'll see in the evidence, that there was an actual valuation of the shares, thinking, what can we get in the market? Actually, what they're saying is they were trying to encourage people to put money in, existing shareholders, by the threat of dilution, by offering it at less than the market. And so to encourage and to coerce, and we say that clearly that is an issue. When the duty is to get the best price, prima facie, that you can do, the question whether they could justify it is a different question.
Now, on that question, one might want to see all sorts of contemporaneous internal documents or whatever. Were they included in disclosure?
Don't believe that they were, but that, my lord, goes to a question of whether we would be able to prove it without cross-examining the witnesses on their own evidence. I'm not sure that...
But both sides might have wanted those materials to be available.
What I'll show you is that I'm going to show you is that the company specifically put an issue in its defence and in its evidence the justification for the rights issue. So the company clearly was trying to justify what it did. And Mr. Broadbent's evidence, which we've got at tab 50, we can go to paragraph 32. Sorry, that's the wrong reference. Paragraph 34, yes, paragraph 34, page 311. He's here talking about what's happened after this launch of Pointer 2. He says the company was in an incredibly weak position, its main product didn't work, existing technology wasn't good enough. So really lowballing the company here. The board discussed how we were in an extremely vulnerable position and had to strengthen the balance sheet. And so he says that's why we considered it. The board also felt there were approximately 10 major projects that the company needed to complete just to survive, and calculated that the company needed in excess of £6 million to realistically stay afloat. Now that is suggesting that the company needed £6 million in cash. To arrive at this figure, the board spent days interrogating financial forecasts down to the smallest details, literally going through item by item. The board was especially concerned that the company avoided a situation where it raised a portion of the money but was then not able to sufficiently strengthen the balance sheet to allow the company to survive. There's much I might ask about that. As the board were very clear that this was the minimum the company needed to survive, I'm confident that the company had done the rights issue at that time, it would not be solvent. Had not done the rights issue, it would not be solvent today. So it's explaining their evidence as to why they did it.
I mean, to be fair, you make the point about the 6 million, but they have also referred in there to strengthening the balance sheet by converting debt to equity.
Quite. But then one might ask quite a lot of questions about, how much cash did the company need to survive? Was it 4 million? Right. But you did a deal where 6 million worth of shares, effectively, based upon this undervalue, where you, the founders, between you got 2 million's worth of shares, effectively, at that price. But you didn't need to take that off the balance sheet to get the cash in. You didn't get cash in. There's quite a lot to be asked about that. And in fact, when you look at paragraph 35, it's now described as an emergency rights issue. Yes, at paragraph 36, it said, in the second sentence, we didn't really have any other credible options. The rights issue seemed like a good compromise given the desperation we were in. If we could reach our target of £6 million, we wouldn't be leaving the shareholders with nothing. The company had a fighting chance of success. Again, the impression is that you needed £6 million to stay afloat, to complete these projects. Paragraph 37, he says that, to legal advice, the board agreed that if we didn't hit the £6 million target, we wouldn't take any investment and would have to enter into administration. The worst thing would be for less than the target £6 million to have come in. And they're not big enough to keep the company alive, and so we go bust 2 weeks later. Again, actually surely 4 million to keep the company alive. That way our investors would have lost even more money, it said. So this is the justification. And you'll see in paragraph 39, we raised enough by the skin of our teeth. In fact, the morning of the final board meeting, I got the last funds in to take us to the total of 6 million. Everyone had the opportunity to invest at the same level, but understandably some investors decided against it. The fact that we only just achieved our target suggested to me that we'd got the pricing just right for the company's value and situation.
So there's an argument about whether it really was at an undervalue at that point.
Right.
If you just take the Brewdog potential deal with Brewdog valuation, then it was at an undervalue. But what he appears to be saying here is that actually, in retrospect, we probably priced it about right.
That's his suggestion, yes. And there's quite a lot.
And that may be right, but that's a matter for evidence.
A matter for evidence, a matter for trial. Yeah. And there is quite a lot that could be questioned about the rationalisation, where they seem to have worked backwards from a figure that they wanted. And it's not clear whether it was 4 or 6, and it would suggest that actually the figure they needed was 4.
Well, there are lots of questions.
There's a lot of questions. And if you just go over the page to paragraph 45, in the end, Magic decided not to take up their rights issue, and so its shareholding remained at 103,000 shares, whilst the total shares in circulation doubled. Of course, Magic now of course had the percentage of a company that benefited from 6 million further of investment. Well, the question is whether that's quite where Magic would agree with that characterisation. Now, the argument that we advance was clearly identified long in advance of and fully argued before the appellate judge, Mr. Justice Marcus Smith. It was set out in our skeleton argument in support of the application for permission to appeal, which was dated the 2nd of September 2024. I will just briefly show it to you, if I may. It's at tab 68, supplemental bundle 2. Page 514, section G. You'll see, this might seem familiar to you because I think we use much of this in our current skeleton, but you'll see 29, 30, 31, it was set out. And paragraph 32, it says it's more than a fanciful prospect that the June 2022 transaction amounted to unfairly prejudicial conduct, etc. Now, as I said, that was the 2nd of September 2024. I think the court has the letter that DWF sent to the court opposing our application for permission to appeal.
Is that the new letter that I I've got.
Yes.
But anyway, just tell me what's in it.
I'll tell you what's not in it. The suggestion that this argument isn't available to us. What it said is, paragraph 2, it's a very long letter. We have considered very carefully, paragraph 3, we have considered very carefully whether or not to write this letter. Sorry? Oh, I do have a spare copy.
Oh, thank you very much.
It's much better way of reading. We've considered very carefully whether or not to write this letter, keeping closely in mind that a response to respondent is not anticipated by the terms of PD 2P. However, we consider the defence of our client's interest leaves us with no choice but to do so. Then goes through in attacking each of the grounds of appeal. And at page 6, it addresses ground 5, paragraph 30, refers to that which I've just shown you. It says that the claim that the unfair prejudice was a failure to secure full value of issue shares is a gross mischaracterisation of what happened in June 2022. What actually happened is debts were converted, the company was released, the effect on the balance sheet was positive. No shares were issued under value at all, etc. Magic's case below was not that the directors of the company failed to get proper price for shares. The only reference to the value of shares was the fact pleaded, paragraph 19, of a prior indicative offer, etc., etc. And then it says, but this is comparing apples and pears, aspirant value and the value that could ensure the company could raise money it needed. So it's not being suggested that it can't be argued. And then it says, in 34, Magic's actual case below was that the unfair prejudice was the supposed breach of the second subscription agreement. But this too lacked any substance. So Magic didn't suggest, sorry, Mr. Broadbent didn't in this lengthy letter suggest that we couldn't run the argument, suggested that we wouldn't win on it. Mr. Justice Trower gave permission to appeal on the 18th of October 2024. We filed our replacement skeleton argument in the same terms as permission to appeal, and that's in the core bundle at tab 13. Let me show you. Mr. Broadbent's skeleton in relation to the appeal was filed on the 25th of April 2025, so nearly 8 months after Mr. Broadbent had received our permission to appeal skeleton. It's in the core bundle at tab 15. And if one goes to paragraphs 91 to 93, at page 158, core 15, page 158. Having addressed the way the argument had been put, relying upon the need to amend or the payment of the founder's loans, then in 91P, so petitioner's attempt to rely on wider matters was not really pursued by P below. I think there's a suggestion that counsel may have accepted there was no effective ability to claim such matters. Then it said 92, a rights issue is not invalidated or improper because the amount hoped to raise is not attained. And then in 93, P's case on a supposed undervalue was purely speculative and only advanced by putting forward a comparison between an indicative aspiration of value in a much earlier unconsummated deal with the price sought in the rights issue. And then it said there is no evidence led by P to establish any actual undervalue and still is not. And indeed, P had actively opposed any reliance on expert evidence. And then 94, however it is examined, P's case remains utterly hopeless. So again, not saying we can't run it, saying the evidence isn't there. It's terrible, was the thrust of that. It was fully ventilated at the hearing before the appellate judge on the 7th of May last year. We give the references for the transcript. I'm not going to take you to them. In our supplemental skeleton argument, paragraph 9, paragraph 10 of our supplemental skeleton argument, we refer to the communications that took place after the draft judgment was circulated. I want to just briefly show you those. They're in SB2, Supplemental Bundle 2, tab 74. The draft judgment was circulated, I think, on around the 7th of July 2025. This is our letter to the judge of the 10th of July, where we invited the judge to address the argument, and we set out what it was, referred to the passages in the skeleton, referred to extracts from the transcript which we provided. At the bottom of page 579, the argument was that the offer of shares in undervalue was inherently unfairly prejudicial in itself, irrespective of whether it involved any breach of the subscription agreement. We set out the references, and therefore, over the page, we lightly suggested that the judgment hadn't addressed the distinct argument and asked the judge to deal with it, which we've seen he did. And just on that, though, in the next tab, tab 75, is a letter sent on behalf of Mr. Broadbent the next day to the court. In paragraph 3, as the appellant notes, it is correct that the draft judgment does not address the question of the alleged claim that the issue of shares was undervalued is accepted. There was an independent contention advanced by the petitioner at the appeal hearing that it had a wider case in respect of the rights issue. However, any wider appeal on such basis can and should be dismissed. And then essentially the points that are made throughout it are attacking the substance rather than whether or not it was available to be run. Now, we say it's therefore far too late to effectively take a pleading point. A learned friend's skeleton engages in a dissection of the pleading and parsing of sentences and paragraphs, which I'll deal with. But the first point is that it was fully argued before the appellate judge without objection by Mr. Broadbent. The court engages with dispensing justice, dealing with the issues presented to it by the parties. Pleading is, of course, the primary way that issues are identified. But of course, if parties allow an issue to be referred to and argued by the court before the court, and if the court adjudicates upon it, then that's the court's decision. A party cannot allow a case to be argued before the court without objection, agree that it should be addressed, and then, when unhappy with the outcome, seek to complain that the court exercised its adjudicatory function and say you shouldn't have dealt it, you shouldn't have done it. Hence, if you're going to take a pleading point, you're supposed to take it. We've put in the bundle the decision of Hawksworth. That was the case in the context of a trial, in fact, where it was made clear that at a trial, if a party runs a case that's not pleaded, you're supposed to take the point and insist on a decision there and then, and if necessary, there needs to be amendments. But if you don't do any of that, you can't on appeal say, well, you shouldn't have allowed it to have happened if you didn't take the point. Now here, the point was long foreshadowed, fully argued, with every opportunity to do so, and it was agreed that it hadn't been dealt with, and it was agreed that it needed to be dealt with. And now, because Mr. Broadbent doesn't like the answer, he says, actually, the judge shouldn't have looked at it.
I wonder how far Hawksworth quite fits onto this. Can I put it slightly differently for a moment? As the case is now put against you, the point should have been taken on the appeal to the judge. They should then have said, there's this extra reason for dismissing the appeal that it wasn't within the scope of the pleadings. Now, that point is revived before us. In terms of how this court approaches things, it commonly allows new points to be run if it doesn't prejudice anybody. And it might be said against you, well, you'd have been absolutely no better off if this point had been taken before the judge. It would have been a good or a bad point then. It's the same good or bad point now. Why shouldn't the respondent be allowed to run the point that he could have run before the judge, that he could have run before the judge?
In my submission, there's a conceptual difference, and so what the court does is decides the issues before it. The court has here decided an issue that the parties effectively agreed was before it. This isn't a case of somebody saying, I accept that there was an undervalue, and then saying later, actually, I want to now argue against the evidence and undervalue and have the fight again. This is, having had the fight, saying, actually, I want to now say that we shouldn't have had the fight. Where the court has actually adjudicated, it's very different to then say, actually, the court shouldn't have adjudicated. Not taking a new point so as to we can then have the argument. It's taking the point to try and close out the argument we've had. And that, in my submission, is what is happening in the Hawksworth type cases in a trial, which is an even more extreme situation, in my submission, where a party can win on a claim or a defence by departing from a pleaded case. Because if somebody doesn't take it, the court decides the case on the issues that effectively have been put before it. You can't then later on appeal say, shouldn't have done that. And that's what's happening here. So it's a different thing, because what they're trying to do on appeal is say, the judge shouldn't have decided the issue we agreed should be decided. My submission, that's simply the wrong way to deal with it. And we say that's the complete answer before we look at the pleading. And the judge considered it was the pleaded case, as you've seen, because he said there were two distinct elements to it. There are extensive criticisms of the pleading, which was settled on behalf of my client. As I've said, there is a contrast in pleading styles between my learned friend and my predecessor on the case. But the document is concise, is not a vice in itself. Pleadings are supposed to contain concise statements of the material facts relied upon. Pleadings don't normally plead the legal consequences. And in fact, my submission, normally, one can argue the legal consequences that flow from the facts. The petition is in the core bundle, tab 23, page 224 begins. If we go straight to page 229, paragraph 19, there's a reference here to the email that I showed you, the one that set out that we were going to effectively dilute you, and it's pleaded that the email went on to stress that we are not saying that this is what the company is worth. Indeed, the Brewdog HMT placed a valuation of 56 million. This is a mechanism to encourage as many shareholders as possible to participate in this round. Now, in paragraph 22, see there's a definition of the June transaction, which is in relation to the issue of the shares. In fact, I think to be technically clear, to be accurate, I think there's a typographical error here in the aggregate subscription price of 451. I think it's 431. But also there were further shares issued after that. That's in evidence. So the story is slightly more complicated than that, but this is generally getting at the share issue. And then over the page, tab section F, unfair prejudice. By reason of, first, the company's breach of the second subscription agreement, and or the June transaction, and or the company's breach of the board seat agreement, the company's affairs have been conducted in a manner that is unfairly prejudicial to the interests of members generally, alternatively some part of its members, including the petitioner. So there are three separate allegations there. Second subscription agreement, the June transaction itself, and the company's breach of the board seat agreement. The words and or make it clear that they're separate.
But what was said to be wrong about the June transaction?
Well, one can extract that from paragraph 26, where it said the effect of the repayment is that the founders of the company have been enabled to retain their controlling shareholdings in the company without themselves injecting any new funds, and at a price per share which Mr. Broadbent expressly recognised as less than market value. And you can see then reference to the cash inflow, and then 3, that shareholding has been diluted. So as my submission, what you are having here is the allegation that the shares were issued at what appears to have been recognised at less than the market value, and the petitioning shareholders have been diluted. Now, what is not in dispute is that the company issued shares, that this had the effect of dilution, nor is it in dispute that Mr. Broadbent had said in his email that the price per share was less than market value. We've actually seen the company's evidence about that as well. Whether there was a justification for the price is an issue that arises from the pleadings, because if we then look at the defence, which is the next tab, the structure of the defence is it pleads a series of facts, and then it turns to responding to the petition by cross-referring backwards. So if we go to page 243, you'll see at paragraph 35, it said, by June 2021, the company had a pressing need to raise further cash in order to finance its ongoing activities. So clearly addressing the rationale for the second subscription offer, which is then pleaded to, it said that explained why it is that it had this pressing need. And then in paragraph 36, the company announced its intention to raise up to £6 million. And you'll see within that paragraph it said, in light of the financial pressures caused by such matters, the email recorded the company's board wished to avoid becoming beholden to the completion of any particular external transaction. As such, it proposed. And then he says, the next paragraph, past the paragraph, the said email clearly identified the dilutive consequence if shareholders failed to take up their rights. The email stated that the company was not necessarily worth just £6 million in the event that an external transaction could ever be consummated. Although the tenor of the email was that without the additional funding required, the company risked running out of cash entirely in 4 weeks and would risk failing to the detriment of all shareholders. So, quite clearly, in issue for the trial was the second subscription offer and the rationale for it, and that's why the evidence addresses it. At paragraph 47, page 246, the submission is pleaded that the effect of Magic's decision not to take up its rights was that it was diluted. By reason of Magic's decision not to take up its rights, it would have inevitably been diluted, irrespective of the partial conversion of shareholders' loans 5 and 6. Of course, the effect of the closing of the second subscription agreement was the company not only secured the cash that it desperately needed in order to sustain itself in business, but it was also correspondingly more valuable based upon the introduction of new cash and the release of creditor debts, but otherwise than by repayment in pursuance of the second subscription offer. Again, so clearly on the pleadings, we were having the debate about why this happened and what the justification was for it. So in my submission, it was right that Mr. Broadbent didn't suggest, in all the time running up to and at the hearing before the appellate judge, that my client's not entitled to run the argument. And the attempt to now advance it in a respondent's notice is, in our submission, wrong, and clearly because they're unhappy about the outcome, which is they can't support the decision given by the judge. And standing back, my submission, it would be a bizarre situation if in the context of a summary disposal, an issue which quite clearly is arguable and has been argued wasn't permitted to be argued. That, in my submission, disposes of much of what I think is going to be said against me by my learned friend in relation to the pure dilution allegation. There's a handful of residual points, and essentially it's to the effect that it said that there was no factual or expert evidence that could have established the undervalue. The court has my point on that, which is that is an issue for trial, effectively wanting to now run through Respondents' notice a summary disposal of this allegation. And the suggestion that it needs to be proven by expert evidence is wrong. We've got the company's own evidence, we've got the company's own contemporaneous emails, and we've got the ability to cross-examine those who have given witness statements about what they said. In my submission, given the evidence, it's clearly more than fanciful that it be established at trial. I might turn my back for a moment.
Are you wrapping up?
I may be, but my lord may have a question.
Yeah. Just thinking, so let's isolate the grounds for a moment. So suppose, forgetting about the nomination agreement argument,
Yes.
We just had this one.
Yeah.
And you say, well, the point you make is well arguable, it's not susceptible to summary disposal, we better go through to trial. How would it work in practice? On this thesis, no amendment to the petition?
If you're with me that it's pleaded, no amendment. If you think it can be improved, or it requires to be pleaded, but we should still be able to run it, then amendment.
Yes, I see.
And we could have directions for that. I have no difficulty with that.
And what about disclosure and witness statements?
Doesn't appear to us that there's going to be any witness evidence from our side, particularly given the modern approach to witness statements for trial. It would just be argument. It seems to us that the company's already, Mr. Broadbent's already traversed the issues. I suppose I should recognise that if there were to be an amendment, then it must follow that there's going to be a consequential amendment, and it must follow that there should be an opportunity for witness evidence. I don't think we've got the CCMC order in the bundle, but I think there might have been provision for a reply witness statement. I thought I saw some heads are being shaken. I may have just made that up. No, I thought I'd seen some reference to that somewhere in the letter.
I did contend for it before ICC Judge Greenwood, but I was unsuccessful on that aspect.
I'm grateful.
And in disclosure terms?
At the moment, I don't anticipate there would need to be further disclosure. We've got our evidence.
Yeah.
As I said, if there is, tracking it, keeping in mind the different alternatives, if there is to be an amendment, and then there's an amendment to the points of defence, then I wouldn't want to rule out, depending on what comes back in the amended defence, whether that gives rise to any further disclosure.
Yeah.
I don't know what we said. So if I may turn my back from
please.
this. Unless I can assist further, those are my submissions.
Thank you very much, Mr. Weatherick. Mr. Doherty.
May it please the Court. In terms of the structure of my submissions, I intend to make a few brief points about the importance of petitions in these types of proceedings and what are expected of documents of that sort. I then intend to take the Court through the petition. We raced through it with my learned friend, but I think the Court, if it looks at the petition, will actually see a number of the issues that are before it are very, very different from the position that my learned friend sought to portray today. I will then go on to examine in detail, in the order that my learned friend did, the nomination complaint and then the rights issue. In the course of that review, I will endeavour to deal with the points that I make in my respondent's notice and also the points that are made against me in my learned friend's supplemental skeleton. Now, the importance of the petition in proceedings of this type has been the subject of frequent comment by the court. These types of corporate divorces had a propensity to escalate into wide-ranging factual disputes that really shed rather less light on proceedings than one would have wished in the position of judging. And the court has emphasised over time the important role that the petition serves in defining the scope of the dispute. Here, the petition was ordered to stand as points of claim. The automatic directions of the ICC court provide for that. There is no separate document comprising points of claim that supplement it. And Magic's case, it falls to be found within the four corners of the petition, fairly construed. And in terms of authorities for that proposition, Retechnion, Authorities Bundle 6, at pages 441 to A to C.
Meaning we should look at them or not?
I don't think they'll be surprising. I've set most of them out in my skeleton argument. Your Lordship has the shape of those points.
Yes.
And I just give the references. Bankside, Authority Bundle 15, paras 115 to 121. Sorry, 15 to 21, I beg your pardon. But recognising there was no points of claim here, just simply the petition. And then finally, on the appeal from Bankside, a case called Re G&G Properties, the court emphasised the importance of role of the petition in paragraphs 34 to 39. Now, if we go to, with that background, the petition, at tab 23 of the core bundle, in my submission, it isn't an impressive document, and it isn't a case of just a pure difference in pleading style or technique. And if I can take the court relatively quickly through the petition, I'm sure the court has read it before. Paragraph 4, we see in the middle of that paragraph that there are 141 shareholders in the company, and a recognition later on that Mr. Broadbent does not hold a majority of the shares. Paragraph 5, again, a recognition in the final, penultimate sentence that Mr. Broadbent and Mr. Dixon were neither of them were majority shareholders. Paragraphs 6 to 12 set out the terms of the second subscription agreement, first and second subscription agreements. I don't need to say much about those. It's essentially narrative. Paragraph 13 to 15 concern the nomination complaint. The date of the relevant letter is misdated in paragraph 14. It is the 25th of March, as we've seen. It is a letter addressed to whom it may concern, and it's framed in terms of entitlement to nominate. Now, the words "to the board," of course, appear, but in my suggestion really add nothing. That tells the recipient and reader of the letter where the nomination actually takes its effect. Paragraphs 13 to 15 are framed exclusively in terms of the entitlement to nominate. One can see, and we'll see later on, the way in which Magic itself interprets the right to nominate in respect of the petition. Perhaps that is why my learned friend did not take the court to this document in the course of dealing with the board seat arrangements. Paragraph 16 is now irrelevant. It doesn't concern this court. It was decided against Magic, and that's not appealed. Paragraphs 17 onwards complain about the alleged repayment of the founder loans. Now, as the court will have picked up from my skeleton argument, this question of whether there was a repayment or a conversion of loans was the only argument over the rights issue that was advanced before the deputy ICC judge, and she dismissed it. The effect of the rights issue had been clearly described in Mr. Broadbent's Dear Investor email. It was intended to raise a total of 6 million, up to 4 million in the form of shares, or at least 4 million in the form of cash, and 2 million, up to 2 million, in the form of the conversion of founder loans. And the judge, ICC judge, held that the conversion did not involve a repayment that infringed the terms of the second subscription agreement, and that is not appealed. But if one looks at paragraphs 17 to 22, one doesn't see there either a complaint that the degree of discount that the shares were offered to was improper, or that the pricing and valuation of the new shares was improper. There is simply, in paragraph 19, a recording of a narrative statement that is made by Mr. Broadbent in that email. And then, in paragraphs 20, 21, and 22, we return to the complaint about the alleged repayment of the principal founder loans. Paragraph, and just to highlight briefly what's not there, there's no hint here that the directors of the company have done anything wrong in fixing the value of the shares. There's nothing that suggests that Magic regarded the value of the shares as what it now frames as an undervalue. Mr. Bestherick, my known friend, took the court to certain emails that had been written by Magic after the announcement of the rights issue. Those don't complain about the pricing. They exclusively focus in on the terms of the ability of Mr. Broadbent and Mr. Dixon to convert, as they put it, repay the founder loans, an issue that Magic lost on and no longer pursues. Paragraph 23 is a rather perfunctory statement, set of statements concerning the board seat arrangements. Paragraph 33 states, the petitioner nominated Mr. Mayor to be a director of the company. However, Mr. Mayor subsequently decided not to seek appointment as a director and was not, in fact, appointed as a director. In its own terms, Magic's case draws the sharp distinction between nomination and appointment that my learned friend protests doesn't exist. This is its pleaded case, and this is the case upon which it has stood and fallen in the two courts below.
In the next paragraph, they say that the company has failed and refused to permit the petitioner to nominate any other individual.
Yes. And
now, just pausing there for a moment, on your construction, nomination means putting forward a name. Well, they weren't complaining they hadn't been allowed to put forward a name. Anybody can put forward a name.
Exactly.
So this allegation makes no sense, does it?
Indeed, it makes no sense. Indeed, Magic doubled down on the...
I mean, just before you go on to doubling down, you can't have understood this as a complaint about not being allowed to put forward a name. Anybody can put forward a name. You must have understood this as a complaint about not being allowed to appoint somebody.
My Lord, with respect, no, we understood it as a complaint that Magic had been denied the opportunity to nominate, that it framed in its own terms in paragraph 23,
You
That's distinct
seriously
from the right to
understood
appoint.
as a complaint about not being allowed to write a letter saying, we suggest Mr. So-and-so should become a director.
Well, that is what Magic has pleaded. It
That's
doesn't
right, but
say...
at the moment I'm trying to understand what the reasonable reader would understand. And I find that implausible.
Well, my Lord, may I just try again? I just refer to the doubling down, if I may.
Yes.
Page 255, the final page of this bundle, is Magic's response to the request for further information. Paragraph 7. Magic denies, in its response, that Mr. Mayor was ever appointed a director, and it reaffirms the case. Well, it's actually in the petition rather than the distinctly in the points of claim.
But where does that get one?
Pardon?
They repeat at paragraph 7 what they said in the petition.
Yes, exactly. Essentially,
That's exactly the same.
It's exactly.
But where does that actually get you?
Well, Magic is complaining that it did not have our cooperation in in nominating somebody to the board of the company. That is all it
Sorry,
says.
what do you mean by that? Your cooperation in nominating? Because if you take nominating as simply suggesting, which is your construction of nominate as opposed to appointing, what does cooperation in suggesting actually convey?
Well, we see Magic has, in paragraph 24, the sole allegation is the company has failed and refused to permit the petitioner to nominate any other individual to act as a director of the company.
Yes,
It has
but
drawn
if you're
a
approaching that on the basis that nominate is the same as appoint, then you can see what they're complaining about.
I could see what they're complaining about, but paragraph 23 essentially adopts that sharp distinction. If Mr. Mayor was appointed a director by the mere nomination by Magic, paragraph 23 would not draw the distinction that it does in the second sentence, nor would it be repeated in the response for further information.
To be honest, I'm not sure really how these precise points on the wording matter, but let's just go back to 15 for a moment. So they say in 15, under proper construction of the board seat agreement, and then they refer to an entitlement to nominate an individual to act as a director. So that means the same, does it? You just have a right to suggest somebody. Well, you don't have a right. Anybody can suggest somebody, but that means the same as what we find later.
Well, I'm assuming that when Magic uses one word in one point of the petition, it means the same as it uses it later.
And does it mean the same in the standard venture capital articles?
Well, my lord, I'll come on to that specifically if I
because
may
this wording is more or less identical, isn't it? Nominate to act as a director.
It is and it isn't. If one looks at the immediate context of the nomination letter, firstly, it's a letter addressed to whom it may concern. It's confirming that the status that Magic enjoys. Secondly, the nomination letter, if it's to be read in any sort of sensible context, can only be read in the context of the constitutional documents of the company as they existed at that time. Now, there's nothing in the shareholders agreement that will assist this court on this issue. But if one looks at the company's articles at the time that the nomination letter was written, March 2021, they adopted Model Article 17.1 of the Model Articles. That provides the appointment, and it doesn't use the word nomination at all, the appointment of directors can be achieved either by way of, one, a decision of the directors, or two, by resolution of the company in general meeting. The context there is all to do with appointment. It doesn't recognise some independent concept of nominating as being effective to achieve an appointment.
Do you say that the emails that we were referred to, which lead up to the letter, the nomination letter, are not relevant factual matrix?
They're not relevant, they're not pleaded as influencing the factual matrix and construction of the letter.
Not as a pleading issue, as a, do you say that they are or they are not part of the factual matrix?
Not on Magic's pleaded case. They are inconsistent with Magic's pleaded case, which is to draw a sharp distinction between nominate and appoint. If that distinction is maintained by Magic's counsel on 2 occasions before judges, it's a bit late now to depart and say, well, actually, a right to nominate means a right to appoint. I will come back to these points, and I'm not endeavouring to skate over them, but my primary purpose at the moment is to look at the petition and just to take the court through the structure of that. The allegations of unfair prejudice contained in paragraphs 25 and 26. Important to note that the floating paragraph under paragraph 25 focuses in on only one part of section 994A1. If you compare the language of that provision against the paragraph in the petition of the authorities bundle tab 1, it doesn't reference the words "are being" that are used in the statute. So it's not complaining about a continuing state of affairs, it just complains about a past set of affairs by the use of the words "have been." Paragraph 26.
What's the significance of that?
It's not an attack that's based particularly on the second limb of section 994, which concerns the conduct of the company's affairs as being conducted in a manner that is unfairly prejudicial. There you would normally be expecting to identify persons who had controlled the conduct of the company's affairs. This is effectively a contractual complaint that is raised on the issues that are identified against the company. It's the company that's being accused of breaching each of these various arrangements over time, that then doglegs into a complaint that Mr. Broadbent must be the target for the remedy ordered against him in the form of a buyout order. Now, just looking at paragraph 26, it's firstly framed in reference to the effect of the repayment of the principal founder loans. That issue has been resolved against Magic, not being pursued. In terms of the subparagraphs, paragraph 3 is really a statement of the blindingly obvious. If somebody does not take up their shares in a rights issue, the inevitable consequence is that they are diluted. But they are diluted in the context of a company that is of greater value, either by the receipt of cash or because the company's conversion of debt into equity improves the company balance sheet position. Those were twin objectives of the what's been called the rights issue in this case. The second objection, the cash inflow to the company was not 6 million, but it was only approximately 4 million, was the exact genesis of the transaction as it was explained to shareholders in the original communication from Mr. Broadbent announcing the offer. It's not a surprise. 2 million was the subject of a conversion that the court has accepted. Mr. Broadbent and Mr. Dixon could effect. The only paragraph that even begins to get towards the argument my learned friend seeks to make is the suggestion that shares were issued at a price per share which was less than the market value. But what that itself doesn't say is the extent of the discount was impermissible. There is nothing there in circumstances where it is recognised by the petitioner that a discount on the issue of new shares in a rights issue is perfectly appropriate to suggest that Magic was maintaining a case that the rights issue pricing was somehow untoward. Indeed, the very author of this pleading did not contend before the ICC judge that the pricing of the shares was an issue. His argument was founded on the notion that there had been a breach of the second subscription agreement. And the breach of the second subscription agreement was the alleged repayment of the principal founder loans before they could properly be repayable under the terms of those arrangements. Paragraph 27 feeds into the board seat agreement, or arrangement, and paragraph 28 comprises the prayer. There is nothing in this petition that explains why, or summarises and explains why Mr. Broadbent is being made a target under paragraph 28(1). But no other person is put forward as a target to relief, and even the company isn't put forward as a target for relief. And the references that I've given the court earlier to the authorities say in relation to the question of relief, it's not enough just for the court to be faced with a contention that, as there is under 28(2), some other or further alternative order might be made. Therefore, this petitioner should stumble on in order to see whether or not the court grants some manifestly different or much lesser form of relief. Instead, it's for the petitioner to specify what it is seeking by way of relief, and indeed substantiate that in the form of the grounds. With regard to Mr. Broadbent here, apart from a singular allegation in paragraph 13 that he was acting on behalf of the company, there is no allegation that in any of the matters complained about, Mr. Broadbent, in corresponding with Magic, where he did so, so far as he did so, was acting on behalf of the company. And we know, objectively, this was a company that had several directors in office at all the material times. Yet it is the company that is said to be in breach. Now, we have no draft amended petition. We didn't have one below on anything relevant. We didn't have anything, indeed, before the ICC judge. Instead, frequently, when questioned by her whether or not he wished to amend, Mr. Head told the court very succinctly, no. And the district judge proceeded on that course. We still have no draft amended petition explaining, my own friend puts it, improving on what Magic's case might actually be. It is all supposedly to be found within the parameters of the petition that we have here and have just looked at. Against that background, I'm pleased to say I don't think there's any contention between us as to the applicable grounds on when a strikeout is appropriate for a case of this sort. So I think that's common ground. In view of the time, may I pick up with the nomination agreement afterwards?
Yes. So 2 o'clock.